The U.S. Department of Justice has changed course and now says it will not defend the anti-discrimination language in the Affordable Care Act. The U.S. Department of Health and Human Services actually promulgated a rule inside of the Affordable Care Act. It was Section 1557 that included anti-discrimination language. It prohibited insurers and any others who offer insurance coverage from discriminating on the basis of disability, race, color, age, national origin, or sex. And it included in their definition of anti-discrimination any discrimination on the basis of gender identity. And that's what's at issue right now in a rule and in the lawsuit. Section 1557 applies the anti-discrimination laws to entities that are also receiving assistance or administering any part of the Affordable Care Act. So this is quite broad. This reaches to a lot of healthcare providers, it reaches to states, and it reaches to insurance companies. And a religiously affiliated insurance company did not want to follow those rules, and a lawsuit ensued. Many states joined that lawsuit, and Wisconsin was one of them. It was Franciscan Alliance versus Azar. Now it's named Azar because that's who the health secretary was. Originally, it was Burwell and then Price. Wisconsin has since withdrawn from that lawsuit, but the suit continues, and it claims, these religiously affiliated insurance companies and states claim, that Section 1557 is forcing facilities to provide services against their medical judgment or religious beliefs. Now, the counter argument to that is that actually Section 1557 provides the very protection the litigants are asking for. It does have exclusions for individuals in certain environments that wish to make a moral objection or a religious objection to providing services. But the lawsuit is ongoing. This case is in the Federal District Court for the Northern District of Texas. If that sounds familiar, it's because that's where Texas versus United States is being heard, in front of the very same judge, as a matter of fact. This is the judge that has to decide whether or not the entire Affordable Care Act should be thrown out based on challenges about the individual mandate. He issued, in this particular instance, a preliminary injunction on parts of the rule that prohibited discrimination on the basis of gender identity and termination of pregnancy. He did not touch those other categories of protected class, that age, race, gender, sex, but he did say that we would issue an injunction on that gender identity piece. Now, the Department of Health and Human Services had to do briefing in this case. They asked for more time to revisit the rule. But then a year passed and no changes were being made. So new motions were filed, new briefings were scheduled. The Department of Justice again asked for more time. But in the meantime, a new Attorney General came along, and the Department of Justice decided it was just going to go ahead and file its brief anyway. And when it did so, it changed its mind. It said, it landed on a much more aggressive position and said they now fully agree with the plaintiffs, those religiously affiliated insurance companies and states that brought the suit. So now the Department of Justice says that Section 1557, that rule language on gender identity, is substantially unlawful. Now they are returning to their prior legal position that sex discrimination does not protect gender identity, a very harsh stance, and that lawsuit is ongoing. Also, a new rule is expected. This came out of rulemaking. So the Department of Justice actually could continue to do briefing, or they could write a new rule. They decided that they would continue to do briefing, but they have said they are still trying to work out the language. So we should watch and see if a new rule is promulgated out of the agency. Now, in the meantime, there has been movement on moral and religious objections, and this is on a different issue. A final rule was actually issued last month on Section 1553 and other sections of law that impact moral and religious objections. It didn't touch as much on this particular issue, but because so many of these anti-discrimination wordings are so similar and apply to similar parties, it's possible that that new rule could impact the litigation at hand here. We have a separate video case tip on Section 1553 and the other moral and religious objection laws that were impacted by the new final rule that was promulgated. You can check that out in the description below. We're also going to put a couple other links there. So you can read the Department of Justice court filing, you can read the original legal position of the Attorney General, and you can read the new final rule on that conscious law that was impacted just recently. If you have questions on any section of the Affordable Care Act or moral or religious objections and how that impacts how healthcare is delivered, you can send us your question, and you can find us at healthwatchwisconsin.org.